Good discussion, talking with elder law attorney Tim Takacs, and a lot of good calls. We have several on the line, so let's just go back to the phones. All right, let's go to Wayne. Is this Wayne right there?
This Wayne.
Good, Wayne. Go right ahead.
Yeah, good evening. Okay, two quick questions. When would you recommend signing a quitclaim deed before it goes to probate? Now, the situation, my mother, when she passed away, she had a will, but she was in the process, but never finished a trust. And the conservator in the will wanted me to sign a quitclaim deed because all the property would go to me because I was sole heir. I felt like if I did, then the creditors would come after me if I signed the property over to her. And her being a consecutor, I don't know how she had the right to do that.
Yeah.
And the next question is there any recommendations you can make on reverse mortgages and any advice you can give to people before they have to do a reverse mortgage? Are there any other choices?
Okay, so let's get to the first question. Is that about doing a quitclaim deed? You know, and we were just having that discussion about that we really don't want people to give away their money or their property, you know, unless they're done with it.
Right.
You know, and even then, it's often not a good idea. You know, so if you're, you know, and it sounded like what maybe his mother was going to do was to set up a trust. So maybe she would transfer her house to a trust, maybe a trust that would avoid probate or for asset protection or for other reasons, and she never got around to doing that. I mean, obviously, what you do is that you do these things, you know, while you're still able to do them.
Right.
You know, that reverts back to, you know, what's your plan? You know, do you want to avoid probate? Do you want the nursing home not to get your money or your property? Is that something that you really need to worry about? You know, and unfortunately, she wasn't able to do it. I don't know why, whether she passed away or she became disabled or incapacitated. But don't wait too late. Mm-hmm. You know, then you lose a chance to plan. And the second question that that Wayne had was about a reverse mortgage. And a reverse mortgage, briefly, it's basically borrowing against the equity of your home, but you don't have to pay it back until you either you pass away, or you move out of the house, or you sell your house.
Right.
So, you know, they are, you know, so these are ways for people that want to stay in their house, you know, if they're healthy and they don't have enough money to be able essentially to pay their bills and pay the taxes and the insurance. Maybe getting a reverse mortgage is a good idea. You know, I'm often asked that, oh, you probably have a lot of people that do reverse mortgages. I say almost none, because my clients are typically, they have chronic illnesses, older people. You know, our job is to plan for their long-term health care and long-term care needs. And those people, we can't expect them to maybe to live in their house for many, many years.
Right, right.
But for healthy older people that are not likely to be moving anytime soon, maybe they're a good idea and don't have other money.
Right.
That's really what they're for.
Right. Yeah, they're people ask about this every time, but that's a good assessment. Thank you. All right, let's go to Barbara. Hello, Barbara. Are you there, Barbara?
Yes, I am.
Go right ahead.
I have two questions. First question is, what's the dollar ceiling that makes things go into probate? I mean, how much money do you have to have your estate probated? And also, I've been told that you can do a payable upon death. I have a few small. I'm not wealthy. I have a few small bank accounts,
right.
And I was just going to do a POD, a payable upon death, to like my brother and his son.
Right.
And how do you avoid probate, and at what point, how much money do you have to have something probated?
Yeah. And that's good that, you know, because we've talked in the past about basically my little thing about how property passes at death. You know, that basically it passes one of three ways. It passes either by operation of law, which essentially means if you own, like say you own a bank account jointly with somebody else, when you die, if it has a right of survivorship, it means whoever the survivor is gets the account. Or if you own real estate, like we've talked about, you know, and you die, then title automatically vests in your heirs. You know, you don't have to do anything to make that happen.
Right, right.
The second way is property passes is by a contract or an agreement. And a third way it passes is by an instruction, a written instruction, which is a will. So a payable on death, and this is what Barbara's asking about, is that she puts on her bank account and says, like there's like in the signature card or whatever, I don't think they use cards anymore. You know, they use like big sheets or whatever. You know, and they write on it, says, who do you want this account to go to, you know, at your death? And you say, you know, my son so and so and my daughter, whoever it is. That's payable on death. That's a contract that you have with the bank, which says basically, when I die, pay these people. That's a contract. It's like a life insurance policy that has a beneficiary designation, same thing. Retirement plan has a beneficiary.
Easy. I like that.
It's easy.
Yeah.
It's really easy. Now,
we're going to have to break though. So is that, what do you want to, the final takeaway for her would be?
Her takeaway is that make sure that your children are, you know, that there is any impediment to them getting it outright. Are they disabled, incapacitated, going through a divorce, a bankruptcy? All those reasons why maybe you should use a trust instead for them to protect it for your children.
All right, Barbara, thank you for that call. We'll take a break. Be back right after this.